This case related to the process for granting Aboriginal land rights in the days before the Mabo ruling revolutionised that area of law. Back then, an application could be made by an Aboriginal group for the transfer of unalienated Crown land. In this case, an application was made, but the application was opposed by Meneling Station, who held a licence to graze cattle over the area. The question was then whether their licence amounted to an equitable interest in land. If they had an interest in the land, then the land was alienated and couldn't be given to the Aboriginal claimants. The graziers claimed to have a profita pendre, which is a right similar to an easement. The party with a profita pendre has the right to take or harvest natural resources from the land in question. The court found, however, that the graziers had a licence, not a profita pendre. Justice Wilson, quoting Halsbury, said, "A mere licence is clearly distinguishable from a profita pendre. It is a personal privilege conferring no interest in the land. It is not transferable, nor can it be granted in perpetuity. It is generally revocable and merely excuses a trespass until it is revoked." Okay, so they had a licence and not a profita pendre. The licence was granted not under the usual common law rules relating to rights in land, but instead under a statute. Did the statute intend to grant a licence which amounted to an interest in land? Justice Wilson looked at characteristics both ways, but this was the killer point. The discretion in the minister in the present case to terminate the licence unilaterally and more or less summarily, without compensation, tends strongly to deny to the licence the character of an interest in land. Furthermore, the Crown Lands Act does not contemplate, in my opinion, any assignment of the licence. It remains personal to the grantee of the licence. So the grazier's licence could be ended at any time for no reason, and they had no ability to assign it, for instance by selling it to someone else. All this suggested that their licence was merely permission to be on the land, not an interest in the land. The land was therefore not alienated and was available for a claim by traditional owners, which was eventually granted.